Liberty Fighters Network.
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 Liberty Fighters Network. Liberty Fighters Network.
Good day, liberators and fellow South Africans. Well, you've all probably heard of the movie called The Man Who Sued God, and as a Christian and as a believer, it did not actually resonate with me at all. And but when you watch the movie, you will see the problem that we've got with where Christianity, we belief and capitalism specifically intermingled with one another, and I always say that my God that I serve is not a God of merchandise. Jesus have chased out the merchants from the temple to say that the temple is not there for merchandising. It's what and how I understand it from what it actually means is that Christianity specifically does not support capitalism, trading. Christianity for me is all about what you've got in abundance you need to share with others. And but in any case, when you watch that movie, you will see that there's insurance companies make use of the term an act of God, which means that that if there's lightning or a storm or something that comes naturally, that's guided by God according to the which is associated with destruction. That's how capitalism have brought God into the capitalist system. But in any case, I'm not here to preach to anyone, but I'm here to share something that is so fantastic. There was this movie, The Man Who Sued God, and now there will most probably be a movie called The Man Who Sued the Court. Lawfully, I need to add, and that person is me. So as ridiculous as it might sound, and initially it was intended to, with all the bashing that and the criticism and the biasness that I have experienced from our court system, while fighting especially the COVID-19 theory in court and everything that went around it. And well, you should remember that on the 1st of July 2021, the Supreme Court of Appeal made that terrible alleged judgment whereby the order that Justice Davis made on the 2nd of June 2020 to declare the lockdown regulations as unconstitutional and invalid was then overturned by the Supreme Court of Appeal on extremely irregular processes and what has happened there. And in that judgment of the 1st of July 2021, there was an occurrence between me and the president of the court, Justice Maya, who is now the Deputy Chief Justice, whereby I've reported the irregularities of the 5 judges that were sitting on that bench. It was Justice Nafsa, Bata, Ponan, Rogers, and Unterhalter. So I've reported the irregularities to her after the hearing of the 26th of May 2021. And that was communication directed to the president as a complaint against him. And that, in terms of the law, and this is where the law in South Africa is selectively enforced in our courts and through our system. So it depends on whether you've got money, whether you've got status, but for the ordinary man in the street like you and me, most of you and like me, the term of justice is just a pursuit of to justice. It's not a real justice that we've got. When you see that statue of this lady with that's blindfolded, and then she's got this weighing, that is that's how justice works. It depends on how much money you put in on this side so that it can collapse to that side, and then the court will actually grant you the benefit of the doubt. But in any case, now what has happened was that through this system of complaint, or through this process of complaint, which is privileged, qualified privileged communication, meaning that it was directed as a complaint to only the president, Maya, of the court. And during those processes, only communication between me and her evolved, not via the state, the attorney, for that appeared on behalf of the Minister of Kochta. And it came to a point whereby she did not want to act against those judges or against the processes. She just basically said, "Oh no, sorry, Mr. De Beer, just get out of my office." And then I've responded with the infamous letter that made so much waves through the entire judiciary and the legal fraternity, whereby I've said that based on an apology that the court sent to me after the 26th of May, whereby the registrar apologized on behalf of the court that oh sorry, you had a point there, but we apologize for the mistake that the court has made. So sorry for that. But then when I approached the president to say, okay, you've made a mistake, you've admitted that you've made a mistake, so please rectify it. And she came back and said, no, she's not going to. I must just wait for the judgment. That was when I wrote the letter. I think it was on the 17th or the 19th of June 2021, whereby I said that after careful consideration, I have decided that the Supreme Court of Appeal must stick its virtual apology up its arse. And that, which happened after the 26th of May, so it was a period where I did not appear before the court. The judges, those 5 judges that I complained against, put it in their 1st of July 2021 judgment that I was contemptuous because of that, and that they found me guilty already without me having the opportunity to have defended myself. And for anyone who knows the law, the term or the doctrine of audi et alteram partem rule, which means that you must have the opportunity to speak in court to defend your viewpoints, have been violated. So that is a basic, very, very hypocritically, inside that alleged judgment of the 1st of July, it was said that the Minister of Cooperative Governance, her rights have been violated by not having been heard regarding the so-called level 3 regulations that were in dispute at that point in time. And the fact that the court has not taken her views on the level 3 regulations into consideration, it made the judgment fatally flawed. And then in that very same judgment, they're doing exactly the same to me. And not that the minister had any rights, because she is the state. She was just a representative of the state. So they made the state already in that judgment, or claimed judgment. It's a purported judgment. It's not a real judgment, people. But in any case, in that they also gave entityship to the state, meaning that the state has become a persona within our constitutional democracy. So well, there was then this process whereby I challenged it to the Constitutional Court to say that the Supreme Court of Appeal it falls under the auspices of the Constitutional Court, because they've made a mistake, and you as the Constitutional Court need to rectify what they have done there, to declare that order they've made as null and void. I could not have, if I've got if I'm in the position to tell the court that I don't recognize your judgment as being valid, I cannot ask for leave to appeal that judgment, because that judgment does not exist. So I cannot appeal something that does not exist. So hence why I approached the Constitutional Court to declare that the judgment of the Supreme Court of Appeal, dated the 1st of July 2021, was a putative judgment. It was null and void ab origin, meaning from the beginning. So I've approached the Constitutional Court, but in that court case, in the Constitutional Court, I've cited both the Supreme Court of Appeal and also its president at that time, which was acting President Petse. Nomine offici, meaning that in his nominated official capacity as the head of the Supreme Court of Appeal. So what happened was that I've created a lot of waves by just submitting that case to the Constitutional Court, and the Constitutional Court came out to say that, well, they've considered my application for direct access, and I have not triggered direct access, and therefore my direct access is not granted. Okay, now what is important here is that if the Constitutional Court has basically indicated that, if the Constitutional Court has indicated that there's a judgment, they've considered everything, and they came to the conclusion that direct access is not granted, it means that they have also, above others, considered the entityship or the persona of the Supreme Court of Appeal, and also acting President Petse, who's in his representative capacity as the representative of the Supreme Court of Appeal. If the court should not have been a party, the Constitutional Court, having said that they've considered everything, should have stated that you are not allowed to sue, or the court is not an entity and it cannot be cited as a respondent during these proceedings. They should have done that. So what I did was I then amplified my approach. I've kept the same parties, but I've changed the relief sort, and I've put in new additional information, and I've reapplied to the court for direct access. And then suddenly the registrar of the Constitutional Court came back to me to say, but this is res judicata, meaning basically that it has already been dealt with by the court. And then I said, but okay, number one, you are not a judicial officer. You are not capable, you don't have the authority to make such a ruling. And you are wrong, because although the elements of res judicata is not present in my instance, because of the fact that although the parties are the same, the relief sought is much different, because it's not the same as the relief sought that but then there was a back and forth, and eventually they refused to issue the application. So what I did was I turned around and took the registrar and the director of the Constitutional Court to the Constitutional Court on an urgent basis to force them to issue my application, which they then, within a few hours after they've received that application, they then complied, and they have then issued my application. So in that instance, I've taken already the court via the registrar and the director of the court, who are officials of the court. So they are acting on behalf of the court. I took them to court. Okay. And they've complied. Okay. That case was also dismissed. And then the res judicata application that they said it was also direct access not granted. So then I said, okay, but I've now got two cases specifically where I've cited the Supreme Court of Appeal and also the acting president of the Supreme Court of Appeal. So let me go, and the Constitutional Court has considered everything, inclusive the locus standi of each and every one of the respondents, inclusive of the court itself, the Supreme Court of Appeal, and also the acting president Petse, who's the nominated official of the court in his official capacity. And so they've considered it, and they've made an order. Again, for the second time, they have not stated that the Supreme Court of Appeal cannot be sued. So when they kicked that to the sideline again, I thought, okay, now what am I going to do? Do they really want me to go and escalate this matter again to the African Commission on Human People's Rights on an international level? Is that their method of the madness of doing it? Or are they basically saying that, well, there's other relief or other processes that I can also follow before I eventually get to them or back to them? And so I've weighed my options, and then I said, okay, well, if the Constitutional Court has confirmed the entityship, the personaship of the Supreme Court of Appeal, let me then sue the Supreme Court of Appeal and its now new President Molemela, Madam Justice Molemela, for defamation in the High Court. So I've issued and compiled that application of that summons, and let me show you that I've done that. Okay, there it is. Okay. So under case number 223-68232, Reyno de Beer and Supreme Court of Appeal of South Africa, Justice Mahubi Betty Molemela. Okay, there it has been issued, and there is the summons. There's the combined summons I've issued against the Supreme Court of Appeal. You can see that it has been stamped and issued. Okay, but what is important here is the particulars of claim. I basically founded my claim to say that, well, I can confirm entityship, that it is a persona, and it can then be sued. And then I've explained the defamation, and I've just literally basically thought, let's make this an effort, and I've sued for sum of 5 million rand, and even if this is going to be a legitimate process, I don't think that I will nearly get that if successful as damages, but yeah, I just wanted to put in a figure at this point in time in order to start the process. So there you've got it. I've actually sued the court. And in our constitutional democracy, whether it's the Supreme Court of Appeal, the Constitutional Court, the Magistrates Court, or the High Court, it's a unified court system. So there's a unity of it's like departments within the judiciary of South Africa. So all of them form part of the judiciary. And when you sue one organ of it, the Supreme Court of Appeal, then you automatically sue the entire judiciary in the same process. It's exactly the same like suing the state. You sue the minister of a specific department as the head of that organ and of that department, and the department is a department within the state. An organ of state. So that's exactly now with the Supreme Court of Appeal. When you sue it, you basically sue the court. And when you've got this process of stare decisis, meaning that there's a precedent system within the ranks of the court, whereby a lower court must adhere to the judgments of a higher court eventually. So in other words, magistrates court must adhere to judgments of all superior courts, the High Court, the Supreme Court of Appeal, and the Constitutional Court. The High Court must adhere to the to judgments of the Supreme Court of Appeal and the Constitutional Court. The Supreme Court of Appeal must adhere to the judgments of the Constitutional Court, and the Constitutional Court is the main apex court, the most highest court in South Africa, and whatever they decide, the other courts, the Supreme Court of Appeal, the High Court, and the Magistrates Court must all follow their decisions. And it's so important that a decision of the Constitutional Court must also be followed by itself. So if you must really have very good reasons why a previous judgment of the Constitutional Court is not should not be followed, and then only the Constitutional Court can change their own judgment. But in any event, now what has since I've served this on the state, on the court in Bloemfontein, and and very importantly, when you issue a court a court process, like in this case a summons, an action process. You get mainly two types of processes in a court. You've got an action process where a summons is issued, and you've got an application process, which is also a motion process where a notice of motion is then issued. It's two different types of processes in the court. But in any case, when you issue a new process, you must also state whether you're going to agree or not agree to the matter to be referred to mediation. And I've filed a notice to agree that the action must be referred to mediation. And my reason for that is that, kindly further note that the plaintiff is me, Reyno de Beer, does so for the reason that the parties should attend mediation first in the interests of the public and justice. So people here, I've also indicated to the court that let's sort this out. Let's just go and mediate this. Let's go and sit around the table and just talk about our differences. That's all. That was the method of the madness at the end of the day, why I took the extreme position to sue the court. And now what has transpired hereafter is simply it's flabbergasted. It really amazed me, because I honestly did not expect the court to act in this way, which have opened up a can of worms, and positively that now they have empowered the people to actually start suing the court for damages. So anyone who has got an issue with a judgment that the court has passed in previously, now the precedent has been set whereby you can now go out and sue the court for that damages that you have received. And so in that regard, let me just go, and how this was responded to amazed me just more. Suddenly, I got this letter from the office of the state attorney, and it says that this was coincidentally by the same person, Mr. Saniboy Zulu, who appeared on behalf of the Minister of Cooperative Governance and Traditional Affairs, and he has now indicated that we refer to the above matter, the Beer versus Supreme Court of Appeal, case number, and advise that we act on behalf of both the first and second defendants. People, the state attorney came in to say that we are the attorneys now of record of the judiciary. For anyone who knows the law, and for all those few good attorneys and advocates still left, and members of the judiciary, judges and magistrates and so forth that's still left, I don't think there are many of them, with all due respect. For all of you who realize the implications of this, where the state suddenly comes in and represent the court, immediately there's the constitutional democracy of South Africa says that now the state is now acting on behalf of the court as if it is one. So the state and the court has become one entity. So there's supposed to be three constitutional pillars. Now all three of those have now become united, and it's not separate anymore. But in any case, what does Mr. Saniboy Zulu, and I just need to add, I honestly think that Mr. Saniboy Zulu is a very good person, and that he is merely an attorney that has been put into this position, and he must act on instructions. So please, people, don't go out and challenge Mr. Saniboy Zulu. I honestly think, and I will show you why I also think that he's a good person. And he has always been treating me with utmost respect from the beginning when he got involved in the first matter in May 2020. So don't crucify him. But in any event, let me show you this further. That he says that Section 47 of the Superior Court, he's asking me to withdraw my case for the reasons that Section 47 of the of the Superior Courts Act provides that no civil proceedings by way of summons or motion may be instituted against any judge of a superior court except with the consent of the Chief Justice. In terms of the common law principle of judicial immunity, judges cannot be sued in the performance of their duties, judicial functions. We trust that you will find the aforesaid to be in order and advise further that this letter will be used as evidence in court should such need arise. So the court or the state has asked me to withdraw the matter. So then I've responded in the following way. So I then said, this is the email I've sent to him. Good day, Mr. Zulu, and I need to read this entire email so that you just understand how basically ridiculous this has become. Good day, Mr. Zulu. It is a pleasure to hear from you again and hope that you are well. It appears as if you have become the dedicated citizen tasked to do risk management for the unconstitutional actions by the state and judiciary alike. It will not be surprised if silk of the calibers of Klingov, Butlinde, Muriane, or Taikobi, or even all of them might join your team soon. When the judiciary's legal team is a total of 11, the number on both sides will then be equal. And then I went on to say that you have proved that you are very good at what you do and deserve such an elite task. Hopefully, no offense directed. The Office of the State Attorney remunerates you handsomely for driving the sewage wagon for them. And at least you ensure that they are legally represented, just like Jeffrey Epstein and Thabo Bester, notwithstanding, are also entitled to decent legal representation. No one ever said being a member of the legal fraternity guaranteed him or her an innocent and lovable client all the time. Enough of petty talk. Your email and accompanied respectfully awkward letter dated the 20th instant refers. The latter is also attached for easy reference for the group of citizens as members of the Court of Public Opinion blind copied herein. Thank you for confirming that the state herein acts on behalf of the one unified judiciary, the Supreme Court of Appeal, as well as its president cited nomine Ufiki. And however, Reiter does not accept the state's representation of the SCA due to the doctrine of separation of powers. Legally, Reiter can simply discard your presence, but as we all know by now and have become used to, the law is selectively enforced as it pleases the courts, depending on the status of those who appear before them, and also their obedience to the British and American expansionists in control of these claimed constitutional pillars, to such point where the court has allowed itself to become an entity capable of being cited and sued in itself. As ridiculous as that might sound, we have all lived the day when the judiciary has formally become an extension of the state, as you have now also confirmed with your brief. Indeed, a Halley's Comet occasion. Notwithstanding, and without accepting the state's representation as being lawful, kindly inform your alleged client that Reiter sees absolutely nothing wrong in law with the summons. In any event, it is not directed at any specific judge as a party and will proceed as normal. Your client's Rule 41A2B notice, together with its notice of intention to defend, are eagerly awaited by the 7th of August 2023. Reiter will see this matter through until the end, even if it must also be referred to the African Commission on Human and People's Rights. The continued torture of Reiter by the state and judiciary will have to come to an end sooner than later. The public and international community are following every step of these proceedings due to many court judgments becoming nothing more than scripts from Monty Python movies the past 3 years, thanks to the COVID-19 theory, which has disappeared as quickly as you were tasked to oppose our early challenge thereof. Reiter's rights remain reserved in toto. People, what is important also about this is now the state, remember that Mr. Zulu, on behalf of the state, has represented Minister Dlamini Zuma as the then Minister of Cooperative Governance and Traditional Affairs before the Supreme Court of Appeal. Now, the state, the attorney of a party to it, is now also the representative of the very court which has given the judgment of the 1st of July 2021 against the judgment of Justice Norman Davis and against us as the party, Reyno de Beer and Liberty Fighters Network. So there they have now proved that entire judgment was coerced and colluded between the state, which was a party to those proceedings, and the judiciary. Automatically making that judgment null and void. That judgment of the 1st of July 2021 does not exist definitely anymore. It's a putative judgment. It's not an actual judgment. Let me go further to what has transpired. I'm totally amazed. And Mr. Zulu, on behalf of the Supreme Court of Appeal, says that kindly take notice that the defendants do not agree to the referral of this matter to mediation. The defendants do so for the reason that, notwithstanding their letter showing the common law principle of immunity and the Superior Court's act not followed and which points were not addressed, plaintiff refused to withdraw its action. There are accordingly no prospects of settling this matter through mediation at this stage. Okay, so what is said in that mediation notice is basically that the court does not want to settle. So the court has become biased in their own matter before themselves. Okay, now let's just continue. And there is the proof we've been all waiting for. There, notice of intention to defend. The defendants, the Supreme Court of Appeal, hereby files the intention to defend the above action, and it's represented by the State Attorney, Pretoria, the defendants' attorneys. Well, anyone that knows the law and the attorneys and the legal practitioners out there will know what implications this have got on our constitutional democracy. It now opens up, here the court, via its attorney, the state, has now confirmed that the Supreme Court of Appeal has become an entity capable of being sued and be cited in court in court processes. And how I've responded. I've responded with a so-called combined Rule 30, and so this is my response. The combined notice in terms of Rule 32B and Rule 30A1. So I said that the first and second defendants have committed either an irregular step and or failed to have complied with the uniform rules of court, in that they have unlawfully lodged a notice of intention to defend on 4th of August, which is in direct conflict with Section 165(2) of the Constitution of the Republic, compelling them to be independent and impartial without fear or prejudice, and cannot have their defense acknowledged before itself, where Section 165(1) of the Constitution establishes one unified judicial authority vested in all the courts. And it further goes on that, further to the above irregularity and or non-compliance, the notice of intention to defend is irregular and or non-compliant with the rules, in that the doctrine of separation of powers demands separation between state and the courts, where the state, via the state attorney, is barred to be the legal representative of the defendants. Alternatively, or to the addition, Section 3(1) of the State Attorney Act prescribes that the function of the state attorney is to represent the government, the state, and not the first defendant, also represented nomine officio by the second defendant, which is not an organ of state in terms of Section 239 under definition of organ of state of the Constitution. And further to the above, the notice of intention to defend is irregular and or non-compliant with the rules because the state is compelled by Section 7(2) of the Constitution to respect, protect, promote and fulfill the plaintiff's rights on the one hand, and on the other, Section 165(4) of the Constitution also compels the state to assist and protect the defendants to ensure the independence, impartiality, dignity, accessibility, and effectiveness of the courts, establishing a clear conflict of interest by being constitutionally compelled to protect the plaintiff and defendants alike, making the state attorney incompetent to represent the defendants in this matter at the expense of the plaintiff. Okay, so I've reacted with this, and this process is now pending. It's busy for being followed. So where does this leave myself and you as a citizen? Number one, the court has now realized that they have created a monster by their own arrogance, accentuated by the misconduct of the state. Now, they have just seen me as an intruder, as a mosquito, and they have, as the infamous Jan Smuts, and I don't like that double agent at all, who has been serving the British crown all the time while fighting on the side, or apparently fighting on the side of the Boers. But in any case, he has said that give them a rope to hang themselves, and sure golly wally, they have hung themselves. Both the state and the judiciary has now exposed themselves as being one. So what is going to happen henceforward? Number one, this is a precedent whereby any one of you who's got an issue with the court, where the court has made judgments which they were not able to do and they have violated your rights by doing that, go and sue the court. Do exactly what I did. Let's go and occupy the court. Each and every one of you who have experienced a negativity or experienced a totally incompetent judgment by the courts of South Africa, and that your rights have been trampled on by this court, which is not an organ of state, which is not part of the republic, as I've indicated in that other video that I've made. Please, people, I will keep you informed about the progress in this one, but this is a real remarkable moment in the history of our true democracy. This have indicated that the constitution has collapsed. We need a new constitution. We need a totally new reformed judiciary in South Africa. Not just a transformed, a reformed. We need to break the whole judiciary down to its foundation and build a new judiciary that is suitable for South Africans and for the Africans as a continent. All these colonial British interferences in our judiciary from the beginning of the establishment of the judiciary must be rid. We must get rid of it. I don't want to serve King Charles. He's not my king. I've got only one king, and that is my God. So he's not my king. And for that matter, this is a process that we all need to follow. The bashing and the prosecution of me will continue. The state and the judiciary have colluded now to prejudice me, to find me guilty of contempt. They are still pursuing, although they don't have the right. They cannot pursue me for contempt of court for various constitutional reasons, but they are busy attacking me. And I'm standing firm. It's only me who's drafting all these papers. I don't have a massive senior legal counsel sitting behind me with an entourage of 5 or 6 junior advocates following me around. I don't have that. It's only me. And that is what's frustrating them. Because someone who is not legally qualified is telling them that the entire system that they are working on, legal system, has failed. We have seen the gaps which they themselves, through their arrogance, have created, and now we're just going in there. As I've said from the beginning, this system, I love the common law principles and the common laws out there, movements. I love them. But I've always said that we need to break the system down from the inside out before common law can come in and it can actually start to mean something. And we have neared the occasion whereby common law, if the court is and I are in battle with one another in a court process, it means that in any court process that I am involved in, I or Liberty Fighters Network or any one of our members are involved in and I'm connected to that, cannot proceed. The court cannot make a judgment because it's automatically barred from making a judgment in a case where I am involved in. So I am now the first person in South Africa who may not approach the court. So the constitution, where I may approach the court to resolve disputes between myself and any other or the state, that right have been taken away from me, because the court, as one unified court system, cannot adjudicate any one of my cases anymore. So I am now compelled to approach international levels of forums, and one of those forums will be the BRICS. I will tell the people what has Cyril Ramaphosa did, how he has connived himself into this COVID-19 theory that he has been pushing in our throats, following the United Nations terrorist attacks on our nation, and I will if I need to eventually go and hide in inverted commas at the Russian Federation embassy, I will do that. I will take my family. If they are continuing with this, I will find refuge in the Russian Federation's consulate in Pretoria. I will go there, or any other country for that matter, and I will say that I am a refugee, a political refugee. The state and the judiciary of South Africa have formally declared war against me. And then let's see whether they can come and start to mediate, sit around the table so that we can talk this out. People, sorry, I know that this is long, but it's important that you listen the entire story, and this is really amazing. But in any case, people, I will keep you informed. Please remember to subscribe and possibly to become a member of our channel, and I'll keep you informed. I'm going to crusade further and see this through until the end, until the day I die, and I'm not going to back down. As long as God is with me and who I believe has chosen me to pursue this, I am happy and I don't have any fear whatsoever, as long as He is with me. Godspeed until the next time.
Liberty Fighters Network.
Liberty Fighters Network.
Liberty Fighters Network.
Liberty Fighters Network.